I've worn this robe for 34 years, long enough to understand that justice isn't simply about statutes and camera footage and what the docket says happened. It's about choices. It's about what a person does in the 4 seconds when they think no one is grading them. And on a bright Tuesday morning in September, a case landed on my docket that looked on paper like a straightforward property damage matter. The clerk set the file in front of me. Serena Wolf, 24 years old, reckless driving, failure to stop, resisting an officer. I read the name, then I read who her father was. The moment she walked in, I felt the air in the room change. Some defendants come in frightened, some come in resigned, some come in performing remorse they have rehearsed with their attorneys. Serena Wolf walked in the way people walk when they have already had a conversation with someone they believe outranks the room. She was 17 minutes late. She did not hurry. The pale blue cashmere sweater was perfectly chosen. Authoritative enough to be respectful, composed enough to signal that she had dressed for something that would not take long. Her dark hair was down, her heels were measured, unhurried. The practiced ease of someone who has attended enough official functions to know exactly how composure is performed. She carried no apology in her bearing because she carried no expectation that one would be required. The real thing she carried into my courtroom wasn't the cashmere or the composure. It was a father's name, and she wore it the way certain people wear a credential. Not displayed, just present, doing its work before she'd said a word. I waited until she reached her table. Ms. Must, Wolf, you were due at 9 hours. It is 9:17. Is there a reason the court was kept waiting? She looked up with the mild patience of someone explaining something self-evident. I had difficulty with parking. No, Your Honor, no apology, just a calibrated insufficiency. The way you answer someone you've already decided doesn't require more. Her attorney stepped forward immediately. Your Honor, we sincerely apologize. I nodded at him. Then I looked back at Serena. Ms. Wolf, this is a court of law. When it convenes at 9 you are here at 9 Are we clear? She met my eyes for a moment longer than necessary. Then, of course, her father was Chief Raymond Wolf, 16 years as the city's chief of police, the longest-serving chief in the department's recorded history. His photograph hangs in the lobby of every precinct in the city. His name has a specific frequency in this city, one that causes institutional systems to adjust around it before anyone consciously decides to adjust. Serena had grown up inside that frequency. This morning, she arrived wearing it. She had brought 2 attorneys, Philip Crane, lead counsel from a firm with a documented history of representing the police union and the city's pension board. A second personal attorney whose separate presence told me Serena understood at some level that this morning might require answers she would have to give on her own. In the gallery's 4th row, Edward Pike and his wife Lucia, who had driven to the courthouse from the Millbrook neighborhood where they have operated their grocery store for 31 years. Edward was in the button-down shirt and light jacket of someone who had closed the store to be here. Lucia had a notepad on her knee. She had not opened it yet. 2 rows behind them in plain clothes sat Officer Dana Reyes. She was not testifying today. She was present in the specific way people are present when something they did correctly is about to be tested, and they need to witness whether it holds. Before I could call the proceedings to order, Philip Crane rose to address the court. He described the matter as a misunderstanding, disputed the characterization of the door contact as resisting, and noted that Chief Wolf had submitted a character reference on his daughter's behalf and was available by phone should the court find it useful. He delivered that last sentence with the carefully calibrated casualness of someone deploying a name that has historically been sufficient. I did not respond to the framing. I asked Sandra Cho to present. Sandra Cho presented the parking lot security camera footage without preamble. She let it do what clear footage does when you simply allow it to run. The Mercedes entering the Millbrook Community Market parking lot. The speed documented at 41 mph in a lot posted at 15. The moment of impact. The rear corner of Edward Pike's delivery truck. The side mirror of the Mercedes shearing off. The visible jolt of the truck on its chassis. Then the 4 seconds at the exit. The store owner's face fully visible in frame. Edward Pike standing in the lot where he had just returned from a delivery run, looking directly at the vehicle that had just damaged his truck. The 4 seconds, the exit. I looked at Serena. I asked whether she disputed that her vehicle had struck the delivery truck. She said with the patient clarity of someone explaining something that should already be understood. There may have been contact, it wasn't significant. The truck was in her way and she was late for something. Her insurance covers incidental parking lot contact. I said, Ms. Wolf, the footage shows you making eye contact with the vehicle owner at the exit. You saw him. You drove away. I want you to explain what you understood yourself to be doing at that moment. One shoulder lifted, a partial shrug, contained enough to be technically acceptable, dismissive enough to be understood by every person in the room. I was late. I assumed the insurance process would handle it. The insurance process requires you to remain at the scene and provide your information. I'm sure my father's office can facilitate the information exchange. The room went the specific still of a room that has just been told, plainly and without embarrassment, that a different set of procedures applies to the person speaking. I looked at her for a moment. Then I said, Ms. Wolf, your father's office is not a mechanism for facilitating civil traffic matters in my courtroom. What your father's office is the reason this court is now going to call him directly on the record. Philip Crane was on his feet before I had finished the sentence. The objection was immediate and professionally delivered. The chief's availability had been offered as a courtesy, not as an invitation to conduct an unscheduled examination on the record in an open proceeding. I asked my clerk for the phone number Philip Crane had himself provided in his own pre-trial filing under the heading Character Reference available for court contact. She read it back to me. I thanked her. Serena's posture changed, not dramatically. She was too well practiced for drama, but visibly in the specific way of someone who expected a name to function as a ceiling and has just been informed that it is going to be examined instead. The call was placed on speaker in open court. Chief Raymond Wolf answered on the third ring. His voice was exactly what 16 years as the city's most senior law enforcement officer produces, measured, authoritative, the specific register of someone accustomed to being called and to the call meaning something. He greeted the court. He said he was glad to be of assistance. He said his daughter was a good person who had perhaps exercised poor judgment and that he was confident the court would take her background and his family's commitment to this city into account. I said, Chief Wolf, I appreciate your taking the call. I want to ask you something directly. The officer who responded to the complaint against your daughter was Officer Dana Reyes, a patrol officer in your department. I want to ask whether you have had any communication with Officer Reyes, her supervisors, or anyone in the department's chain of command regarding this matter since the citation was issued. A pause. Chief Wolf said he may have indicated to her supervisor that he was aware of the situation and was monitoring it. I said, Chief Wolf, I want to make sure the record reflects what you just told this court. You contacted the supervisory chain of the officer who cited your daughter in a matter where your daughter is the defendant to indicate that you were aware of the situation and monitoring it. I want to ask you whether you understand what that communication functions as in the context of this proceeding. A longer pause. I understand how it might be characterized. I am not asking how it might be characterized, Chief Wolf. I am asking you to tell this court what you intended it to communicate. The silence that followed was the silence of a man who has been asked on a speakerphone in an open courtroom to describe something he understood clearly at the time and understands clearly now and was hoping would never require a public description. He said, I wanted to make sure the situation was being handled appropriately. I said, Chief Wolf, the situation was being handled appropriately. Officer Reyes filed a complete report, documented the door contact and the verbal statement, and submitted the building security camera footage as a supporting attachment. The situation was being handled appropriately before you contacted her supervisory chain. What your contact communicated, regardless of your intention, was that a senior department official was monitoring the handling of a case involving his family member. This court is going to address that. I ended the call. Serena was looking at the bench. She was no longer managing her posture. She was simply sitting in the specific way of someone who has watched the infrastructure they assumed was permanent shift beneath them in a single conversation. Sandra then asked to present one additional piece of evidence, the apartment building security camera recording. The audio was captured from the camera mounted above the door, clear and without distortion. Do you know who my father is? You will not have a job tomorrow. Serena's voice, unambiguous. The courtroom held it. Serena said she had been upset. She said she hadn't meant it literally. I said, Ms. Wolf, Officer Reyes filed her report. She submitted the parking lot footage. She documented the door contact and the verbal statement. She did all of that without adjustment, despite a direct statement from you that she would lose her employment for doing so. This court wants Officer Reyes to know that this proceeding has noted what she did and how she did it. Sandra then addressed one remaining matter. In the 2 weeks between the citation and this proceeding, Edward Pike's delivery truck had remained out of service. His insurance company required the at-fault party's information to open a claim. Serena had not contacted Edward, had not contacted his insurance, and had not provided her information through any channel in the intervening 14 days. The documented lost delivery revenue across those 2 weeks was $1,840. I looked at Edward Pike in the gallery and asked if he would like to address the court. Edward Pike stood. He is not a person who performs emotion, and he did not perform it now. He stood with the steadiness of someone who has been doing difficult things for a long time and has learned that the difficult things do not require an audience. He said he had owned the Millbrook Community Market for 31 years. He had paid his taxes and his employees and his vendors every week for 31 years without exception. He was not asking for anything beyond what the law already provides. Then he looked at Serena directly. I just needed her to stay. That is all I needed, 30 seconds. She looked at me and she left anyway. I want her to understand that I saw her and she saw me and she left anyway. The room held that sentence the way rooms hold things that have been said with complete precision and require nothing added to them. I looked at Serena. Ms. Wolf, you came into this room this morning operating on a specific assumption that your father's position meant this room would behave differently. Your attorney mentioned his availability. This court found it useful to take him up on that. What this court learned from that call has been referred to the Department's Office of Professional Standards for formal review. Your assumption did not protect you here. It became part of the record. I want you to think carefully about what you assumed this morning and why you assumed it, and whether you want to keep carrying that assumption into every room you enter for the rest of your life. The ruling was this: on the reckless driving charge, an $800 fine, full court costs, and a mandatory defensive driving course to be completed within 60 days. On the failure to stop, a $1,200 fine plus full restitution to Edward Pike, $4,200 in documented truck repair costs, and $1,840 in documented lost delivery revenue, totaling $6,040 to be paid within 30 days directly to Edward Pike. On the resisting charge, 60 days suspended, 18 months of formal probation, and mandatory completion of a law enforcement community relations program. Her driver's license suspended for 90 days beginning today. And then the addition I had been considering since the footage played, since the 4-second pause at the exit, since the face visible in frame, 30 hours of community service at the Millbrook Community Market, not a charitable donation, not a check, 30 hours of physical presence at that store stocking shelves and assisting customers, and learning from the inside what 31 years of a neighborhood business requires of the people who run it every day. Serena said, "You can't require me to." I said, "I can, and I have." Philip Crane was on his feet immediately with detailed objections. I noted each one for the record. I did not change a single element of the ruling. The department's Office of Professional Standards opened a formal review within 48 hours of the court's referral. 2 members of Officer Reyes's supervisory chain had received direct communications from Chief Wolf following the citation. Both acknowledged being aware of the chief's interest in the matter. Both were formally counseled. Chief Raymond Wolf received a formal letter of reprimand, the first in 16 years of service, placed in his personnel file. He did not contest it. Officer Dana Reyes was not disciplined. She received a formal commendation for the completeness of her incident report and the quality of her supporting documentation. She continued her patrol assignment. Serena completed the defensive driving course within the 60-day window. She paid the full restitution to Edward Pike within 30 days, a check from her personal account with a handwritten note on plain paper. I should have stopped. Edward Pike did not frame the check. He framed the note. He put it behind the counter at the Millbrook Community Market in the same row as the family photographs. Serena completed all 30 hours of community service at the Millbrook Market. She arrived on time for every shift. She did not speak much in the first 2 weeks. In the third week, she helped Lucia Pike reorganize the back storage room and stayed 45 minutes past her required time to finish the job properly. When Lucia thanked her, Serena said, "I'm sorry I didn't stop." Lucia said, "I know." 6 months after sentencing, I read a notice in the municipal court's professional newsletter. The city's police department had implemented a new protocol requiring mandatory ethics training for any officer or senior official whose immediate family member receives a citation from a department employee. The protocol was attributed to findings from an OPS review. The review had been opened on a referral from this court. I keep that in the same drawer where I keep the things that remind me why I put the roll bond in the morning. The thing I think about most when I think about this case is not the ruling or the referral or the protocol. It is the parking lot footage, the 4 seconds at the exit, the face visible in frame, Edward Pike standing in his parking lot looking at her, her looking at him. 30 seconds was all he needed. That is the whole of it. I want to say something directly to everyone watching this. This story is not about a police chief or a daughter or a parking lot collision. It is about something that happens every day in cities everywhere. A name that causes systems to adjust before anyone consciously decides to adjust. The adjustment doesn't require a phone call. It doesn't require a threat. It happens in the ambient pressure of a name that has functioned long enough in enough rooms that the rooms begin to anticipate it. Dana Reyes filed a complete report anyway. Edward Pike memorized the first 4 characters of a license plate and called from the landline anyway. They both understood that what came next would depend entirely on whether the room they reached would read what they brought. This room read it. Chief Wolf's contact with the supervisory chain became part of the record. His daughter's assumption became part of the record. The note behind the counter at the Millbrook Community Market says, "I should have stopped." That note framed next to the family photographs is what justice actually looks like when it functions, not as punishment, but as a 30-second accounting that someone was finally asked to make. That is what this bench is for, not for the name on the precinct photograph. For Edward Pike, for Lucia, for Dana Reyes, who filed her report and submitted the footage and waited to see whether it held. It held. Share this. Subscribe. Justice still has a pulse. It was always meant for everyone, not just the people whose fathers have photographs in lobbies.